Good morning, good afternoon and good night learners. Let's learn the law, civil justice and tort law. Unit 4 Precedent and Interpretation. This unit looks at which cases are the most powerful and persuasive. It does this by looking at lots of old legal concepts, which unfortunately tend to be known by their Latin names. Edward Marshall Hall, perhaps one of the most famous barristers ever, was once asked by a judge, "Surely Mr. Marshall Hall, your client is familiar with the concept of res ipsa loquitur." "Of course," said Mr. Marshall Hall, "where my client comes from, they speak of little else." In the previous unit we assumed the law was certain, but in this unit we're going to explore what happens when the law is uncertain. People are most likely to need the help of a lawyer when rules are uncertain, and these are also the types of cases that are more likely to be appealed to the higher courts so that the law can be clarified. To help you develop your practical skills as a lawyer, the unit explains how to look up cases and legislation, and how to check whether they're still reliable and up to date. Finally, once you have a good understanding of legal reasoning and precedent, the unit concludes by asking whether judges make law. Historically, this has been a somewhat controversial question for the common law, due to the fact that judges are not democratically accountable, and in addition, as we've seen, judges tend not to be representative of wider society. Sliding Doors and Stare Decisis. The film Sliding Doors follows two histories of a character played by Gwyneth Paltrow. One follows what happens to her if she catches her train, and the other if she misses it. As you can imagine, this small twist of fate leads to two totally different outcomes. In Unit 3 on legal reasoning we found that some cases are difficult, or hard, so that one judge might decide one way and other judge might decide the other way. Imagine if Gwyneth Paltrow was a judge and her missing the train meant the case was assigned to another judge who would have made a different decision to her. If cases were decided differently depending on which judge happened to be assigned to a case, this could seem unfair. The losing party might well ask why they could not have a judge that would have decided the case in their favor. You have also seen that in hard cases it is difficult to know what the right decision is. The first judge to decide a legal problem might suggest a rule that afterwards turns out to cause more problems than it solves. A second judge faced with a similar case might be tempted to apply a different rule. But this would cause uncertainty because nobody would know whether a judge is going to follow a previous judge or decide a different way. The common law legal system therefore needs a method of balancing flexibility and certainty, and this method is known by its Latin name of stare decisis. Stare decisis just means letting the decision stand. The earlier case becomes called a precedent, because later courts are expected to follow it. In general, decisions in cases are allowed to stand, even if they might not be perfect. This provides certainty for the public and the parties. At the same time, higher courts can overturn decisions by lower courts, which provides some flexibility. The Incorporated Council of Law Reporting. Stare decisis became particularly important after 1865 when the Incorporated Council of Law Reporting, ICLR, was established. Law reporting is the publishing of judicial decisions so that the public can know the law and how cases have been decided. Before 1865, law reporting was a bit haphazard. Without a reliable law report, it was more difficult to be sure what previous courts had decided. A court that did not want to follow a particular precedent could cast doubt on whether the law report was accurate. For example, Lord Lyndhurst was reported to have said of the unfortunate law reporter Mr. Barnardiston, who wrote reports published between 1726 and 1735, "I fear that is a book of no great authority. I recollect, in my younger days, it was said of Barnardiston, that he was accustomed to slumber over his notebook, and the wags in the rear took the opportunity of scribbling nonsense in it." William, 1882, p. 424. The establishment of the ICLR effectively put an end to judges querying law reports. After that time, the draft ICLR reports would be returned to the judges to check that the report was accurate. It would also include the arguments of the parties so that the context of the dispute was clear. Precedent for prediction and persuasion. Practicing lawyers use the rules in cases for persuading a court in addition to predicting how a court would decide. If the lawyer can find a previous case where the judge applied a rule similar to the case before the court and where the litigant in their position previously won, the requirement to follow stare decisis can force the judge to find in their favor, even if the judge would not want him to win otherwise. This makes finding supportive cases an important skill for a lawyer. Later in the unit you will look at the mechanics of how to do this. How influential a rule in a case is as a precedent depends on a number of factors. These include Whether the judge's rule is central to the determination of the case, or more of a speculative comment. Whether the court is a senior or junior court. How similar a precedent case is to later cases where the parties seek to apply it. These factors will be considered in turn in the following sections. Ratio decidendi and obiter dicta. The first factor that influences how persuasive a rule is whether the rule was key to the outcome, or whether it was just a speculative comment by the judge. If the rule was key, then it can be binding on later courts, whereas speculative comments are only persuasive and do not need to be followed. It is therefore necessary to distinguish between them. The two types of rules also tend to be called by their Latin names. The binding type of rule is one that actually decides the case. This is known in Latin as the ratio decidendi, or reason for the decision. Sometimes it is shortened just to ratio. All cases must have a ratio because it is the rule that the judge applies to decide the case, and also the judge must explain this in their reasons. For example, in the circumstances of the case of McLennan v. McLennan. 1. If the judge had decided that the partner who became pregnant by artificial insemination had not committed adultery, then the ratio might be something like, a married woman who becomes pregnant through self-impregnation does not commit adultery. The ratio is obviously the most important part of a case. There is no easy way to identify what part of a case is the ratio. Holland and Webb, 2019. Court reporters such as those who work for the ICLR will try and identify the ratio in the summary of the case, but the reporters do not always get the ratio right. Judges themselves rarely try to highlight the ratio in their own decisions, but they may use the phrase when discussing what part of a previous case might be the ratio. As a result, spotting the ratio is a skill that comes with practice and familiarity with case reports. The second type of rule is the one that is not binding. Judges sometimes like to offer comments about hypothetical and related circumstances that they do not have to decide. They do this to explain their thinking and check that the rules that they are applying make sense. This is also known by its Latin name of obiter dictum, meaning an incidental comment. Sometimes this is also shortened to just obiter. Rules that are obiter are not binding on later judges, but they may be persuasive. For example, in the case of McLennan v. McLennan, when giving reasons, the judge might have said something like, of course, and hypothetically speaking, it might be the case that a married man might offer his sperm to somebody other than his wife for reproductive purposes and without having intercourse. While these are not the facts before the court today, my view is that those circumstances would not amount to adultery either. If there was a later case that happened to fit those facts, then the earlier judge's comments would not be binding, but they would be influential. Exactly how influential depends on how senior the court is. Obiter from a judge in the Supreme Court carries a lot more weight than obiter from an adjudicator in the Traffic Penalty Tribunal. The second factor that determines how influential a rule in a case is how senior the court is. Or to put it in comedy terms, if a court looks down on other courts, it is more influential than a court that looks up to other courts. The judicial hierarchy. The second factor that influences whether ratio decidendi is binding on the court depends on where the earlier court is in the judicial hierarchy compared to the later court. In general, appeal courts are more senior than first instance courts. Second-level appeal courts, like the Supreme Court, are more senior than first-level appeal courts, like the Court of Appeal. Higher-level first-instance courts, like the High Court, are more senior than lower-level first-instance courts, like the County Court. Therefore, if the precedent is from a more senior court than the court hearing the new case, then the precedent tends to be binding. But if the precedent is from a more junior court than the court hearing the later case, then the earlier precedent tends not to be binding, but it may be persuasive. This allows the more senior court to make changes to the law. The situation where the earlier and later courts are at the same level is a bit more complicated. In general, courts at the same level consider themselves bound by their previous decisions, subject to two exceptions. The most obvious exception is where the earlier precedent is problematic because the court ignored something important such as a relevant statute or another binding precedent. When a court has ignored a relevant precedent, that decision is called by the Latin phrase, per incuriam, meaning given carelessly. If a later court decides that a precedent was given per incuriam, then that later court can decide not to follow it. A court can also ignore precedent at the same level if it is inconsistent with another precedent at the same level. For example, if there are first and second precedents of the Court of Appeal that conflict with each other, then the Court of Appeal in a third case does not have to follow either of the first or second precedents. This situation tends to happen where the decision of the second court was reached in ignorance of the first decision, i.e., per incuriam. These exceptions were explained in the case of Young v. Bristol Aeroplane Company Limited. The High Court can be both an appeal court and a first instance court. When it is an appeal court, it follows the above rule and binds itself, subject to the same exceptions as the Court of Appeal above, per incuriam or conflicting decisions at the same level. When the High Court is a first instance court, previous first instance cases of the High Court are not binding. This is the same for other first instance civil courts such as the County Court, because first instance courts do not bind each other. However, in practice, first instance courts will tend to follow each other unless there is an obvious problem with the earlier authority. Back in the day, the House of Lords, the predecessor to the Supreme Court, also treated itself as bound by its previous decisions. See London Tramways Company Limited v London County Council. Closing parenthesis. This caused a problem because if the House of Lords made a mistake, the only way of overturning its mistake was to wait for Parliament to bring in a statute to overrule it. The House of Lords realized that there was a problem, and in 1966 issued a practice statement giving notice that in the future it would not bound by its previous decisions. See Practice Statement, Judicial Precedent, 1966. Closing parenthesis. After 1966, the House of Lords began to overturn some of their previous decisions. For example, recall the case of Duncan v. Camel Laird, discussed in the previous unit, where the House of Lords had ruled that a public interest immunity, PII, certificate from the government that disclosing evidence would risk national security was the end of the matter. This principle was not followed in Conway v. Rimmer, where the House of Lords ruled that it could scrutinize whether such a PII certificate was in fact justified. The Supreme Court now follows the same approach and can overrule its previous decisions. The third factor that determines whether a precedent is binding is whether the material facts are sufficiently similar, or analogous. Analogy in law. Whether rules in cases are binding also depends on whether the facts of the cases are similar enough, or analogous, to each other. There are three different possibilities. On the one hand, if the material facts in the two cases are identical, then the earlier case is binding and the later court must follow it. On the other hand, if the material facts are completely different, then the earlier case is not binding. Here, the later court can ignore it and either follow another precedent, or establish a new principle. Between these two extremes there are many different gradations. Given the rich tapestry of life that comes before the law courts, many cases fall somewhere in the middle. This obliges the lawyers and the judges to grapple with the question of whether the cases are sufficiently similar. If a court decides that the facts in an earlier case are similar, but not similar enough, then this is called distinguishing. Quite how people, or lawyers, assess whether two things are similar or different is frankly something of a mystery. In general, we might assume that one type of apple is more similar to another type of apple than an orange. But as soon as we look at a specific case, this assumption becomes unreliable. For example, if somebody ordered sweet juicy Cox's apples from an online supermarket, and the supermarket replaced the Cox apples with some Bramley cooking apples, that are very sour, the customer might have preferred that they had been given oranges. The same happens in law. The aspects of cases that influence whether lawyers treat cases as the same are not well understood. Holland and Webb, 2019, pp. 146-47. As a result, deciding whether a case is similar enough to be treated as a precedent is something that comes with practice and experience, and even then, trained lawyers may disagree. Certainty and uncertainty. Legal rules can be certain most of the time, but there are circumstances where they will be uncertain. The legal philosopher H.L.A. Hart, who was based in Oxford, talked about the penumbra of uncertainty. Now, penumbra is just a fancy word for half shade. Where the light cast by the sun or a light shines on something, you'll find that there's an area which is definitely in the light, and there's an area which is definitely in the shade. But between the two, there's an area which isn't quite in the light, and isn't quite in the shade, and that's the penumbra. Now, legal rules are the same. There are circumstances where the rule definitely applies, and there will be circumstances where the rule definitely does not apply. But sometimes there's a small area, the penumbra of uncertainty, where it's not clear whether the rule applies or whether it doesn't. So Hart suggested there are at least two reasons why legal rules were uncertain. The first is a problem with human language. It's very difficult to explain everything perfectly clearly with human language, as opposed to computer language. And secondly, it's sometimes very difficult for the rulemaker, parliament or a judge, to predict every possible circumstances where the rule might apply. A famous legal example of uncertainty is whether or not a Jaffa cake is a cake or a biscuit. The issue matters very much to the producers of Jaffa cakes, because cakes are VAT-free, VAT-exempt, so they don't need to pay tax, whereas there is tax on biscuits. Now, a digestive is clearly a biscuit, whereas a Battenberg is clearly a cake. But Jaffa cakes fall somewhere in the penumbra of uncertainty. They're small like a biscuit. They're covered in chocolate like a biscuit. They're sold in packs like a biscuit. But they're soft like a cake, and many of the ingredients are the same as cakes. This issue was the issue in the real-life case of United Biscuits in 1991. And in that case, the judge in the VAT tribunal decided that a Jaffa cake was a cake, which was good news for the manufacturers of Jaffa cakes. As you have explored in this unit and the previous one, rules contained in parliamentary statutes and common law cases are crucial for a lawyer. In the next section you will find out how to find statutes and cases and to check if they can still be relied on. Finding cases and statutes. Finding law that supports your case is a key skill for a lawyer. When you become an expert in a particular area of law, you will know most of the primary case law and statutory sources. However, while you are familiarizing yourself with an area of law, your starting point for research is most likely to be a secondary source such as a legal textbook. Through your study you will gain enough knowledge of the law to identify the relevant area of law. You will learn about the differences between criminal law and the civil law. Then you will learn the types of civil law such as contract and tort. And then you will learn the types of tort like negligence, defamation, trespass, breach of statutory duty, etc. This should give you enough of an understanding to find the relevant primary sources in a textbook. Books can only summarize the cases and legislation and are less authoritative, so ultimately you will need to read the cases and legislation yourself. Textbooks are like a map, but one that can rapidly go out of date. Appeal courts overturn previous cases and Parliament enacts new statutes on a daily basis. A nightmare that brings practicing lawyers out in cold sweats is that of standing up in court and referring to law that is no longer in force. This means that you should always use an up-to-date textbook and also check that cases and legislation referred to in textbooks have not been overruled or superseded. A generation ago, this was a slow and laborious task, but thanks to databases such as Westlaw and Lexis, it can now be done with a few clicks of a mouse. Later in this section we will see how this is done. Do judges make law? Now that you are familiar with the mechanics and practical side of doctrinal law, we can turn to look at an old philosophical question about this law. We have seen in this unit and the previous unit that some cases are hard, meaning that there is not always a clear rule for a judge to follow. When this happens, judges seem to have a choice about which rule to make, and they often could choose between making a number of different new rules. We have also seen that historically, much of the common law was created by judges. Whether judges make law is important because it raises fundamental questions about fairness. An important common law and human rights standard is that of the so-called rule of law. The rule of law requires, amongst other things, that the rules that apply to people's behavior are clear in advance. If judges make up legal rules only after you have already done something, this seems unfair because you could not have complied with a rule before it existed. A losing party in a court case might justifiably be upset at losing if the rule they should have followed is set out only after the dispute arose. There is also another concern about judges making law. Judges, unlike elected politicians, are not democratically accountable. If they are not accountable to the community, it seems wrong for them to be making the law. This is aggravated if you also recall that the individuals who become judges in England and Wales are not yet representative of the wider community. In the past, the answer to such worries was said to be the declaratory theory of law. It was argued that judges did not actually make the law, they only declared what everybody knew the law was. For example, Sir William Blackstone wrote in 1766, "It is not in the breast of any subsequent judge to alter or vary from according to his private sentiments he being sworn to determine, not according to his own private judgment, but according to the known laws and customs of the land, not delegated to pronounce a new law, but to maintain and expound the old one." Blackstone, 1766, p. 69. For a long time, the declaratory theory of law was widely accepted, but it was famously attacked by one of the most famous British legal philosophers, Jeremy Bentham. For example, in a colourful short pamphlet, he attacked the entire common law as bastard law, that was made, just as a man makes laws for his dog. When your dog does anything you want to break him of, You wait till he does it, and then beat him for it. Bentham, 1823, pp. 11-12. When Jeremy Bentham died, he asked that his body be preserved. This was done, and the body was subsequently presented to University College London. The body is now displayed and can be visited. The head has been replaced with a wax copy because the actual head is too disturbing for general viewing. Judges as legislators. If you think back to some of the exercises and cases considered over this unit and the previous one, some of the situations seem quite tricky. It was not always obvious what the legal rule should have been. Some other recent cases also challenge the idea that judges are merely declaring what the law should be. For example, in R. Smeaton v. SS Health, Munby J. had to decide whether prescribing the morning after pill amounted to the offense of supplying poison to procure a miscarriage, contrary to the Offences Against the Person Act 1861. Obviously anxious to avoid being seen to be making law, he wrote, 47. The issue which I have to decide is not whether the sale and use of the morning after pill is morally or religiously right or wrong, nor whether it is socially desirable or undesirable. What I have to determine is whether it may constitute an offense under the 1861 Act. The commentator David Kelly, 2020, p. 515, is scathing about these words, writing, with the greatest of respect to Munby J., what he seeks to avoid is exactly what he is forced to do in making his legal decision. Munby J. eventually ruled it was not a crime. In the present day, the pendulum has swung back the other way, such that many now accept that judges make law. For example, Lord Reed writes, "There was a time when it was thought almost indecent to suggest that judges make law, they only declare it. Those with a taste for fairy tales seem to have thought that in some Aladdin's cave there is hidden the common law in all its splendor, and that on a judge's appointment there descends on him knowledge of the magic words 'Open Sesame.' Bad decisions are given when the judge has muddled the password and the wrong door opens. But we do not believe in fairy tales anymore." Reed, 1972-73, p. 22. If judges make law, then common law is at least partially retrospective, and therefore unfair. Bentham's solution was to do away with the common law and attempt to codify the law in its entirety. It is fair to say that Parliament legislates more than it did when most people believed in the declaratory theory of law. At the same time, present-day judges are less interventionist. Where there seems to be a problem with the law, they are not always happy to set out a solution. Instead, they sometimes refuse to act, saying it is a matter for Parliament. For example, in R. Nicklinson v. Ministry of Justice, the appellants suffered from debilitating conditions and wanted to commit suicide, but were unable to do so without help. While it is not a crime to commit suicide, it is a crime to assist. The appellants sought declarations of incompatibility under the Human Rights Act 1998. The majority of the court thought that they had the power to give a declaration of incompatibility, but refused to do so, saying that the issue was one for Parliament, not the courts. Summary. This unit began by explaining how you decide which cases are the most powerful and persuasive so that you can predict how a court will decide, and also so you can use these cases to persuade a court to decide in your favor. The unit also introduced you to the idea of uncertainty in legal rules and explained how lawyers deal with uncertainty. Finally, we examined the knotty philosophical question of whether judges make law. You should now be able to explain stare decisis, describe and distinguish between ratio decidendi and obiter dicta, recognize that some legal rules are uncertain, discuss whether judges make law. Please like, comment and subscribe.